A slap on the doorstep. Robert Jackson sat behind the wheel of his black sedan in the pale dawn light, the soft drone of the engine mingling with the distant hum of traffic. He inhaled deeply, tasting just a hint of autumn chill in the crisp air. Every morning, he followed the same routine. Coffee at Archibald's on 22nd, then a straight shot down Pine Avenue to the federal courthouse. Today, though, his mind was elsewhere, buried in a stack of briefs for a multi-million-dollar white-collar fraud case. He checked his reflection in the rearview mirror, crisp navy suit, silver lapel pin, cufflinks gleaming, and exhaled. He was a federal prosecutor, and he knew the power of appearance in a world that judged men by the cut of their coat and the color of their skin. Across the street loomed the red brick courthouse, its neo-classical columns bathed in morning light. Years ago, from that same entrance, Robert had watched a parade of defendants shuffle past, their futures weighted by suspicion. He remembered his first day as an Assistant U.S. attorney, how the polished marble floors had made his heart pound. But nothing rattled him now, except one man, Judge Harold Emerson. Emerson had sat on that bench for nearly 3 decades, carving out a reputation for both brilliant legal mind and, whispered in hushed tones, entrenched bias. Robert had seen the judge's ruling patterns: leniency for defendants who looked like him, severity for those who did not. Yet he had never imagined he would witness such raw prejudice face to face. He slipped out of the car and adjusted his tie before crossing the street. The courthouse steps loomed tall, each slab of stone worn smooth by countless footsteps. With purposeful strides, Robert passed through the revolving doors and into the hushed stillness of the main hall. The marble floors gleamed under the chandeliers, and the air smelled faintly of polish and powdered robes. He greeted the receptionist with a nod and made his way to courtroom 7B, where Emerson held session on Tuesdays. Inside, the gallery was already filling. A handful of spectators clustered along the wooden benches, an elderly woman clutching a small purse, 2 teenagers in hoodies whispering to each other, and a middle-aged man in a denim jacket fidgeting near the back. Robert took a seat toward the front, flipping open his leather portfolio and scanning over yesterday's filings. He knew this would be only a few minutes of his morning. Then back to the U.S. Attorney's office, where diligence demanded his full attention. The bailiff's voice rang out. "All rise. The court of the Honorable Judge Harold Emerson is now in session." A collective rustle sounded as everyone stood. Emerson entered, black robes swishing, his white hair perfectly coiffed. At a glance, he seemed the epitome of judicial gravitas. Stern black eyes beneath arched brows, lips pressed in a thin line. Robert allowed the clerk to announce his presence, and then lowered himself back into his seat. The first case called was State of Brookfield versus James Harris. Robert looked up from his notes as Harris, a young black man in a plain sweater and jeans, stood at the defense table flanked by a public defender. Harris's crime: jaywalking across Main Street. In most jurisdictions, it would have earned a warning or nominal fine. But as the hearing began, Robert felt a familiar tension coil in his chest. "Mr. Harris," Judge Emerson began, voice cool, measured. "You plead guilty to count 1, pedestrian violation. The statute clearly prohibits crossing in areas without proper crosswalks." He paused, eyes narrowing as he regarded Harris. "Your explanation of being in a hurry is, frankly, insufficient. You must understand that traffic laws exist for everyone's protection. Yes, even yours." Emerson's lips curved into a thin smile. "Let this be a lesson to you. The next time, you won't be so lucky." Murmurs rippled through the courtroom. Harris opened his mouth to speak, but the judge cut him off with a lifted hand. "No excuses. The fine is $500, plus $100 in court costs. Pay up within 30 days, or we issue a bench warrant." With that, Emerson looked down at his gavel. Robert heard the soft rap as it fell. "Court is adjourned." When the bailiff called for recess, Harris bent to retrieve a small piece of paper, his receipt, and shuffled away. Robert watched him go, noticing the slump of his shoulders, the look of stunned disbelief on his face. It wasn't just the fine, it was the dismissal of his dignity. Robert's jaw tightened. He had prosecuted corruption in high places, defended vulnerable communities, and advocated for justice. Yet here, before his very eyes, a man was being punished far beyond the bounds of reason. Silence settled over the gallery. The judge glanced up, spotted Robert in the front row, and raised an eyebrow. Recognition flickered across Emerson's face. Was it surprise? Robert couldn't tell. He sat up straighter, holding the judge's gaze, refusing to look away. A bead of sweat formed at the corner of his jaw. "I'm a federal prosecutor, Daniel," he told himself. "My jurisdiction is absolute." Instead of applauding the end of the proceedings, Robert rose and walked deliberately to the bench. The room fell into an uneasy hush. Emerson's clerk cleared her throat as Robert stepped into the well. "Your Honor," Robert said, with a steadiness he had practiced countless times in arguments before juries. "May I have a moment?" The judge's expression shifted to mild irritation. "This isn't your case, counselor," he replied. "Please return to your seat." Robert drew a deep breath. "With respect, sir, I am not counseling on this matter as defense or prosecution, but as a citizen. That fine and those court costs are staggering for a pedestrian violation. Mr. Harris is a college student. He's working 2 jobs just to pay tuition." Judge Emerson tapped his gavel lightly. "I understand your concern, counselor, but the law is clear. My decision stands." A flush of anger warmed Robert's cheeks, but he held his ground. "With all due respect, Your Honor, justice requires discretion and compassion. I would ask that you reconsider imposing penalties that border on punitive rather than regulatory." The judge's eyes narrowed. A low murmur ran through the spectators. Then, as quickly as it had started, it ended. Emerson leaned back, his posture regal. "Counselor, this court does not solicit second-guessing from the bar. If you have business before this court, you may address it in proper filings. Otherwise, take your seat." Robert inclined his head once and returned to his bench, heart hammering. He did not reveal who he was, though the credentials in his pocket glinted like a silent threat. Instead, he opened his portfolio and pretended to take notes, watching the judge's inscrutable face. As the gavel fell again and the next case was called, Robert's mind raced. He would not allow this injustice to stand. But first, he had to decide how to proceed. There would be no half measures. For James Harris, and for every other person unfairly condemned by prejudice, Robert Jackson would bring the full might of the U.S. Attorney's Office to bear. The echo of that first gavel lingered as he closed his portfolio. Justice, he vowed, would not be denied, would not be a strategy in motion. Robert Jackson stepped off the courthouse steps into the sharp morning air, the echoes of Judge Emerson's gavel still reverberating in his ears. He paused beneath the colonnade, eyes scanning the bustling street. Commuters jostled past, oblivious to the injustice that had just transpired behind those tall oak doors. But Robert was neither idle nor silent. With measured calm, he drew his phone and tapped out a terse message to his chief, Laura Chen. Judge Emerson's jaywalking fine decision, $500 plus costs, raises serious concerns of bias. Request meeting as soon as possible. Within minutes, Laura replied, "Be in my office at 10. We'll discuss next steps." He tucked the phone away and hailed a cab. The city's grid of glass and granite blurred past as he replayed the courtroom scene in his mind. The judge's dismissive tone, the impassive expression as a man, an ordinary citizen, was saddled with an unduly harsh penalty for a trivial infraction. That man could have been anyone. An out-of-town visitor, a retiree, a single parent. Instead, today's victim was Robert himself, though Emerson did not know it. His credentials as Assistant U.S. Attorney were carefully concealed beneath a borrowed suit and a low profile. Robert had entered the courtroom simply as Robert Jackson, citizen. Now he would unmask himself. At precisely 10, he was ushered into Laura Chen's office. Sunlight slanted through floor-to-ceiling windows, illuminating row upon row of leather-bound volumes. Laura, a woman in her early 40s with steel-gray streaks at her temples, rose and offered a firm handshake. "Bob," she began, "I got your text. Tell me what happened." Robert recounted the jaywalking hearing, omitting nothing. The summary fine, the judge's curt refusal of any plea for leniency, and the sense that race had played an unmistakable part in Emerson's severity. Laura's expression darkened with each detail. When he finished, she stood by her desk, steepling her fingers. "This isn't simply an overzealous application of traffic law," she said. "It reeks of prejudice, and it happened right under your nose." She turned to her credenza and retrieved a printed docket sheet. "I did some digging. Over the past 5 years, Judge Emerson has fined black individuals for minor violations at twice the rate of white defendants. That disparity isn't just statistical noise, it's a pattern." She slid the paper across the desk. "This could be a Title VI issue. We're going to need hard evidence." Robert nodded. "I've already requested audio recordings of every Tuesday morning session for the past year. We'll pair that with sentencing data, line by line. If bias influenced those rulings, we must prove it." Laura leaned back. "Good. I'll authorize a civil rights inquiry. Meanwhile, you should file a formal judicial complaint through the Administrative Office of the U.S. Courts. Make it concise, fact-based, and bullet point the disparities. I'll review before it goes out." He opened his notebook. "I'll have a draft on your desk by end of day." She glanced at her watch. "Time is of the essence. If word gets out that a federal prosecutor lodged this complaint, Emerson will push back hard. He might accuse you of overreach, claim you're politicizing traffic enforcement. We need to control the narrative." Robert inhaled. "Agreed. I'll prepare a press statement clarifying that this is a matter of judicial integrity, not politics. Once the complaint is filed, we'll invite the Fifth Circuit's Judicial Council to review." Laura gave a curt nod. "Proceed." Back in his office, Robert settled before his laptop. He began the complaint draft with a succinct summary of the hearing. On June 30th, 2025, at approximately 9:15 a.m., Judge Harold Emerson presided over State v. Jackson, docket number 7B, charging me with pedestrian violation. The imposed fine of $500 plus $100 in court costs for jaywalking, absent any aggravating factors, constitutes disparate treatment. He paused, then typed, "This decision departs markedly from the standard practice in this jurisdiction, wherein such infractions routinely incur fines not exceeding $50. A statistical review of 124 comparable cases from June 2024 to June 2025 indicates that similarly situated white defendants averaged fines of $47. Black defendants averaged $312. He imported a spreadsheet detailing fines by race. Robert drafted footnotes referencing each case. Then he outlined the legal basis. Pursuant to 42 U.S.C. Section 1983 and Title VI of the Civil Rights Act of 1964, judicial actions driven by racial animus violate constitutional guarantees of equal protection. I respectfully request that the Judicial Conduct and Disability Act be invoked to investigate potential misconduct." Hours passed in intense concentration. He refined the language to maintain professionalism and avoid inflammatory rhetoric. At 4:45 p.m., he attached the spreadsheet and supporting audio transcripts, then sent the draft to Laura. Within minutes, her approval pinged. "Looks solid. I added references to Canon 3B5 of the Code of Conduct for U.S. Judges regarding impropriety and appearance of bias. Go ahead and file." Prepared, Robert logged into the AOJC portal. He filled in the appropriate forms, uploaded the complaint, and hit Submit. A confirmation number flashed, AOJC-2025-0897. He exhaled. The formal process was now underway. But a complaint alone would not be enough. He needed to ensure the matter reached public consciousness in the right way. He opened a new document. Press Statement. Confidential Draft. Today, a federal prosecutor filed a judicial complaint against the Honorable Judge Harold Emerson concerning the disproportionate imposition of fines on black defendants. This action reflects a commitment to equal justice under the law, not partisan politics. He wrote a Q&A anticipating pushback. Q. Why is an Assistant U.S. attorney getting involved in a pedestrian violation? A. When a judge departs from standard practice in a manner suggesting racial bias, any citizen, especially those sworn to uphold the law, has a duty to act. Q. Is this politically motivated? A. Absolutely not. This complaint arises from a documented pattern of disparate treatment and is grounded in data and transcripts. Satisfied, Robert saved the file and scheduled it for release the morning after the AOJC confirmation. That evening, Robert's phone buzzed with a news alert. Breaking. Federal prosecutor files complaint against Brookfield judge for racial bias. He frowned and tapped through the link. Headlines varied, some neutral, some sensational. Already comment threads accused him of grandstanding. A few local attorneys weighed in, praising the effort. Others criticized him for undermining judicial independence. He knew the second wave of reaction would be stronger. Calls to the local bar association, editorials in the Brookfield Gazette, social media storm. His next priority would be maintaining focus on facts, not emotion. Before shutting down for the day, Robert glanced at his reflection on the darkened screen. His forehead creased slightly. Fatigue tugged at his shoulders. This was no trivial side project. It was a fight for the soul of the judiciary, and an affirmation that justice must mean everybody. He tapped his phone one more time. To Laura. Complaint filed. Press statement scheduled. Next step. Data analysis presentation to Fifth Circuit. Estimate 2 days. Laura. Excellent. I'll arrange. And Bob, thank you. He closed the laptop and gathered his coat. Outside, the street lamps flickered on as dusk settled. Under their glow, the city's shadows lengthened, reminders that prejudice, too, lurks in dark corners. But tonight, Robert Jackson carried a light of accountability, and he was ready to shine it wherever bias hid. Tomorrow, the fight continued. And he would not relent. The judge strikes back. Robert Jackson entered the federal courthouse annex clutching 3 binders filled with transcripts, charts, and audio excerpts. Magistrate Ruiz met him in a conference room bathed in morning light, her gray eyes keen and focused. Assistant Jackson, she began. Your complaint demands careful review. Robert connected his tablet to the conference monitor and displayed a slide. Average fines for minor infractions. $300 for black defendants versus $47 for white, across over 100 cases. These disparities can't be random, he explained. All cases were comparable. Jaywalking, open container, and other nonviolent misdemeanors with no prior offenses or aggravating factors. He advanced to a chart showing confidence intervals and p-values beneath 0.01. Ruiz nodded thoughtfully. Your methodology is rigorous. We'll open a preliminary inquiry under the Judicial Conduct and Disability Act. Judge Emerson will be notified today and given 10 business days to respond in writing. A panel will convene shortly thereafter. Across town, Judge Harold Emerson discovered the AOJC notice placed before him on a polished mahogany desk. The typed allegations of racial bias, detailed statistical analysis, and direct involvement by a federal prosecutor caused his jaw to tighten. He summoned his chief clerk, Walter, to his chamber. Gather every transcript and recording for the past 3 years, he ordered. I intend to draft a thorough rebuttal that highlights my adherence to sentencing guidelines and judicial discretion. Emphasize that fines correlate with public safety concerns and deterrence, not with race. When Walter warned that the counsel would seek raw datasets, Emerson replied, give them everything. We'll annotate each case. And send my statement to the press. These charges are baseless attacks threatening judicial independence. Alone, he stared at the ornate wallpaper, recalling every tough sentencing decision he had rendered. He felt righteous, convinced he upheld the law, yet an uneasy whisper of doubt lingered beneath his resolve. Back at the U.S. Attorney's office, Robert met with Aisha Patel, the civil rights counsel known for her precision. They gathered around a glass-walled conference table strewn with printed proposals. Aisha pointed to a list. Expert testimony by Professor Samuel Wilcox, distinguished for his research on implicit bias metrics. Amicus briefs from the NAACP Legal Defense Fund, American Bar Association, and several community organizations. Amicus support can underscore systemic issues beyond this individual case, she noted. Robert added, we'll coordinate a precise constitutional brief, Title VI and equal protection grounds. I've scheduled Professor Wilcox to testify on regression analyses and controlled experiments demonstrating implicit bias in judicial decisions. Together, they outlined hearing logistics, subpoena schedules, and exhibit lists, then confirmed the panel's likely timeline and venue. That afternoon, Robert contacted James Harris to prepare his witness statement. Harris, still shaken by the judge's $600 total fine, expressed relief at the opportunity to reclaim his dignity. In a nearby cafe booth, Robert listened as Harris described the humiliation of explaining the charge to family and missing shifts to pay the penalty. Robert promised, "We'll seek restitution and highlight the human impact before the council. Your testimony will show the emotional harm of biased rulings." He arranged pro bono civil counsel to explore damages and offered transportation and accommodations for Harris's appearances. As he left the cafe, Robert felt a renewed sense of purpose. This was no abstract fight, but a defense of real lives. As dusk settled, Robert noticed an email from the Brookfield Bar Association, an emergency luncheon titled Judicial Conduct and Community Trust. He confirmed his attendance, aware the luncheon would shape local legal opinion. That evening, he drafted speaking notes, an opening statement on data integrity, a middle section on the constitutional imperative of equal protection, and closing remarks invoking justice as the judiciary's cornerstone. He practiced delivering them, mindful of tone and clarity, so his words would resonate without rancor. Meanwhile, Judge Emerson convened informal meetings with fellow jurists and civic leaders to shore up support. He distributed memos summarizing his decades of service and defended each contested ruling with case citations. In a radio interview, he stated, "Judges must apply the law and protect public safety. These accusations mischaracterize my intentions and threaten separation of powers." He emphasized judicial independence, warning against political interference. Yet privately, he reviewed his own sentencing notes late into the night, questioning whether any personal assumptions had crept in. He suppressed the doubt, convinced that his path was just. Over the following days, preparations intensified on both sides. Robert and Aisha finalized expert declarations and legal briefs, enumerating direct quotations and context for Emerson's rulings. Laura Chen scheduled interviews with local outlets and drafted op-eds for broader distribution. Walter delivered Emerson's response, a 6-page defense and historical memos on regional sentencing norms. Each side knew that when the Judicial Council panel convened, the hearing room would become a crucible for tradition and accountability. Robert paused at his office door before sleep, resolved to face whatever came with integrity and unwavering commitment to justice. Tomorrow, the challenge awaited him. The hearing hall. The grand hearing chamber of the Fifth Circuit Judicial Council, filled with a hushed murmur as spectators took their seats. 3 council judges, each draped in flowing black robes, presided from a raised dais, their silver hair framing solemn faces. Behind them, a crest bore the scale of justice, its beam tipped ever so slightly. At center, a long oak table waited, microphones gleaming beneath pale overhead lights. Flanking the dais, clerks arranged folders and water glasses. In the gallery, journalists leaned forward, pens poised over notepads. Even the air felt charged, as though prejudice and accountability hung in delicate balance. Robert Jackson stepped forward with Aisha Patel at his side. He carried 2 bound volumes identical in size. One contained transcripts, the other statistical exhibits. He nodded curtly to the panel before placing them on the polished surface. Across from him, Judge Emerson's counsel, Martin Hayden, slid a legal pad and fountain pen into view. Harris sat quietly beside Robert, hands folded in his lap, his expression resolute yet nervous. At the back, Professor Samuel Wilcox arranged charts on an easel, while news cameras whirred softly. Robert adjusted the microphone and cleared his throat, the gravity of this moment settling over him. When the Chief Judge spoke, his voice was cool, but measured. "We convene today to consider a complaint filed by Assistant U.S. Attorney Robert Jackson against Judge Harold Emerson. Counsel Jackson, you may proceed with your opening statement." Robert straightened his tie and exhaled. "Thank you, Your Honor. This proceeding addresses the disproportionate fines imposed by Judge Emerson on black defendants, in violation of equal protection principles. We will demonstrate through statistical evidence, expert testimony, and personal accounts that these actions reflect systemic bias, not judicial discretion." His gaze swept the panel as he spoke, unwavering. Martin Hayden rose to respond. "Your Honors, Judge Emerson's record reflects decades of impartial service. Traffic infractions are penalized to deter unlawful conduct and maintain order. Variations in fines stem from case specifics, neighborhood safety concerns, defendant attitudes, and prior warnings. The allegations of racial bias misunderstand the context in which these decisions were made. He paused, allowing the argument to settle. We ask the counsel to dismiss this complaint and uphold judicial independence. The judges exchanged silent glances before signaling Robert to continue. Aisha Patel introduced the first exhibit, a color-coded graph mapping fines by race. Exhibit A, she said, shows 124 cases between June 2024 and June 2025. White defendants averaged $47 fines, black defendants averaged $312. The standard deviation is too narrow for this disparity to be random. She handed the chart to the clerk, who passed it to the panel. Robert then summarized key data points, emphasizing confidence intervals and probability thresholds. We believe these numbers alone warrant inquiry, he concluded. Next, Professor Wilcox took the stand. Wearing a tailored suit and thick-rimmed glasses, he referenced prepared slides. Implicit bias arises when unconscious associations influence decisions. Controlled experiments have demonstrated that decision-makers, judges included, can unknowingly impose harsher penalties on individuals of certain races. My analysis shows a correlation coefficient of 0.76 between defendant race and fine severity, controlling for all other variables. He fielded questions about methodology with calm authority, citing peer-reviewed journals. His testimony lent scientific weight to Robert's charge. Hayden rose to cross-examine. Professor Wilcox, can implicit bias account for legitimate factors like neighborhood crime rates or the demeanor of defendants in court? Wilcox nodded. My model controls specifically for those variables. The residual disparity remains significant. While demeanor may affect outcomes, it does not fully explain why defendants of identical profiles receive markedly different fines based solely on race. Hayden frowned, but offered no further objections. Then James Harris was called. He walked to the stand, shoulders squared. Your Honors, he began, voice steady. I jaywalked across Main Street near the courthouse on June 30th. I wasn't aware of a crosswalk and hurried to work. Judge Emerson fined me $500 plus $100 costs. I worked 2 part-time jobs to attend college. This fine forced me to skip shifts to pay it. I felt humiliated, like I was punished for who I am, not what I did. His eyes glistened as he spoke of missing family dinners and nights sleeping on a friend's couch. The room fell silent. Judge Emerson took the stand next. He spoke with measured dignity, recounting the rationale behind each fine. These penalties were calibrated to serve as genuine deterrents in high-traffic zones known for pedestrian accidents. My discretion considered public safety above all. Race played no part in my decisions. Under probing questions from the panel, Emerson defended his record, but hesitated when asked about comparative cases involving white defendants. His counsel interjected, urging clarification, and the judge excused himself with a curt apology. The counsel judges then posed questions. One asked Robert whether he had encountered similar discrepancies in other jurisdictions. He cited studies from neighboring circuits showing comparable patterns. Another questioned Wilcox on alternative research interpretations. Wilcox reaffirmed his conclusions. When they turned to Emerson, one judge gently pressed, "Did you ever question whether your perceptions of defendants influenced your rulings?" Emerson's jaw tightened. "I rely on facts, not assumptions." He paused, then conceded that implicit attitudes are difficult to fully eradicate, but insisted he had always striven for fairness. After 2 hours of testimony, the chief judge declared a recess. As spectators filed out, reporters jostled for quotes. Robert gathered his materials and moved toward Harris. "You did great," he whispered. Harris nodded, relief mingled with exhaustion. Outside, cameras swarmed as Hayden and Emerson's spokespeople defended the judge vigorously. Robert recognized that public opinion would now shape the wider narrative just as much as the legal record. Alone in a quiet corridor, Robert allowed himself a moment of reflection. The hearing had exposed raw truths, the power of data, the courage of a young man, and the stubborn complexity of bias. Yet the outcome remained uncertain. He knew the counsel would deliberate in private before issuing an opinion. Whatever their decision, Today's confrontation had already sent ripples across the judiciary and the community. As twilight deepened, Robert stepped onto the courthouse plaza. Streetlights flickered on, and the marble columns glowed against a bruised sky. The fight for justice would continue, through motions, appeals, and perhaps policy reforms. But today, a spotlight had illuminated the fault lines in a system that prides itself on fairness. He pocketed his phone, braced for messages and calls, and walked into the gathering dusk, determined to see accountability through to its end. The counsel's countermove. Morning sunlight streamed into Robert Jackson's office as he reviewed the Judicial Council's request for additional briefing. The hearing had exposed cracks in Judge Emerson's record, but the counsel now demanded deeper analysis of how public safety concerns intersected with the stark racial disparities in fines. Beside Robert sat Aisha Patel, Civil Rights Counsel, her laptop open to a detailed spreadsheet. Professor Wilcox had confirmed his availability to testify should an appeal become necessary. Robert tapped his pen thoughtfully. To prevail, he said, we must show that Emerson's safety rationale masks a consistent pattern of bias. Aisha nodded, adjusting her annotated outline, and Robert added entries to a timeline juxtaposing safety data with each contested ruling. Before the morning briefing with Laura Chen, he drafted a concise memo listing the counsel's 3 core questions: the weight of safety factors, the consistency of messaging, and the unexplained fine disparities. Across town, Judge Harold Emerson sat in his wood-paneled chambers, reading the counsel's order by lamplight. The preliminary opinion required him to explain whether his higher fines for jaywalking and related infractions reflected genuine public safety imperatives or unconscious bias. He summoned his clerk, Walter, and reviewed binders of pedestrian accident reports. These numbers, Emerson mused, demonstrate a 23% spike in injuries near the courthouse steps this spring. Walter nodded, handing over transcripts of each hearing. Emerson tapped his pen against the oak desk, his robe slipping from his shoulders as he leaned back. He drafted bullet points defending his approach. Fines serve as deterrents in high-risk zones, each penalty accounts for location-specific hazards, and no defendant received lesser sanctions when similar conditions applied. He resolved to append letters from police chiefs and neighborhood associations praising his stringent enforcement, convinced that judicial independence would vindicate him. Back at the U.S. Attorney's Office, Robert and Aisha divided the supplemental brief into 3 meticulously crafted sections. The first summarized constitutional equal protection jurisprudence, citing Yickwo v. Hopkins and McCleskey v. Kemp, to ground the counsel's inquiry in Supreme Court precedent. The second presented a comparative analysis. White defendants averaged $47 fines for similar infractions, while black defendants averaged $312. These figures emerged in side-by-side bar charts, annotated with confidence intervals and p-values below 0.01. The third section deconstructed Emerson's safety argument, pointing to 4 white defendant cases in identical zones that incurred nominal penalties. Aisha inserted footnotes referencing a 2019 meta-analysis on implicit bias, and Robert overlaid municipal zoning maps showing visibility and lighting conditions at crosswalks. By 6 p.m. they had finalized a 40-page PDF, locked to prevent unauthorized edits, and uploaded it to the council's secure portal. Meanwhile, Laura Chen convened a press conference on the courthouse steps, flanked by Robert, Aisha, and civil rights advocates. Cameras clicked as she spoke from beneath a bronze plaque, quoting Justice Thurgood Marshall. Today we submitted a targeted supplemental brief reaffirming our commitment to equal justice under the law, she declared. A reporter shouted, "Doesn't this politicize the judiciary?" Laura replied swiftly, "This process is data-driven and respects due process. It is not political. It is principled." Another journalist pressed on potential backlash. Robert stepped forward. "Our goal," he said, "is transparency and fairness, ensuring every citizen, regardless of race, receives equal protection." Community leaders behind him raised supportive placards, and the assembled crowd murmured in approval. Op-eds flooded Brookfield's news outlets. The Gazette warned of prosecutorial overreach and the dangers of undermining judicial independence, while the Tribune published a guest column, "When Justice Speaks Up," lauding Robert's data-driven challenge to entrenched bias. Local legal blogs dissected the nuances, and a 10-minute video clip of Robert explaining the statistical findings went viral, drawing thousands of views. The hashtag #CountEveryCase trended regionally on social media, with hundreds of personal anecdotes of minor infractions shared in solidarity. Robert instructed Laura's team to amplify favorable commentary and immediately correct any misleading claims with official statements. Simultaneously, Judge Emerson appeared on the radio program Brookfield Morning Talk, hosted by Marie Delgado. Live on air, Delgado asked, "Can bias ever be fully eliminated in judicial rulings?" Emerson paused before responding. "We must rely on rigorous training, transparent decision-making, and ongoing review. I welcome this scrutiny to strengthen public trust." Callers phoned in. One praised his integrity and dedication to safety. Another questioned systemic racism in the courts. Emerson fielded each with measured civility, though his tired eyes betrayed the strain of public exposure. At the conclusion, he thanked the host and affirmed his full cooperation with the council's process. That evening, Robert confirmed via encrypted email that the council's portal had recorded his supplemental brief at 11:47 p.m. Across town, Emerson finalized his own 40-page defense. A cover letter, accident statistics, character letters from senior district attorneys, and a detailed log of every jaywalking case he had presided over. He dispatched it by courier at 12:05 a.m., ensuring delivery before the council's midnight cutoff. Both documents now awaited the council's secretariat, where clerks would organize materials for the judge's review. Robert then drafted a 5-point scenario analysis for Laura and Aisha, ranging from outright dismissal to private or public censure, and outlined strategic contingencies, including potential appeals to the full Fifth Circuit and legislative referrals to amend traffic enforcement guidelines. In the quiet aftermath, James Harris prepared for his upcoming finals, balancing constitutional law textbooks with email notifications about the council's case number. He drafted an essay on equal protection for his class, reflecting on how a single jaywalking ticket had catalyzed systemic scrutiny. He messaged Robert, "This will change things, won't it?" Robert replied, "It already has, James. Your courage is the spark of reform." As midnight deepened, Robert sat in silent reflection at his desk, the glow of his computer screen illuminating spreadsheets and legal briefs. The clash between accountability and autonomy had escalated, but his resolve remained unshaken. Tomorrow, the council would weigh not only numbers but the nation's promise of justice. Behind closed doors, late afternoon sunlight slanted through the tall windows of the Fifth Circuit Judicial Council's private deliberation chamber, where 3 judges gathered around a polished mahogany table. The room was hushed, its high ceiling echoing only the soft rustle of papers and the occasional scrape of a pen. At the head sat Chief Judge Miriam Gates, her steely gaze fixed on sprawling binders of exhibits. To her right, Judge Samuel Ortega leafed through detailed statistical graphs. To her left, Judge Helena Price reviewed Professor Wilcox's transcript. None spoke at first. Each absorbed the weight of their responsibility to balance judicial independence with constitutional protections. "Let us begin," Chief Judge Gates finally said, voice even. "We have received 2 substantial filings: the Assistant U.S. Attorney's complaint with supporting data, and Judge Emerson's formal defense. We must determine whether this constitutes misconduct warranting censure, admonition, or dismissal." She tapped a printed agenda. "Judge Ortega, your thoughts on the evidentiary threshold?" Ortega adjusted his glasses. "The statistical disparity is stark. A near 7-fold difference in average fines between black and white defendants for comparable infractions. Professor Wilcox's methodology is sound. Under Canon 3B5, a judge must avoid even the appearance of bias. Here, that appearance is undeniable." He paused. "However, the council must consider context. Public safety concerns, accident data, local enforcement guidelines. Humorously, Emerson's accident statistics show a legitimate uptick in pedestrian injuries near the courthouse." Judge Price interjected, "But those accident reports do not justify punitive disparities. 4 white defendants in the same vicinity received fines under $50 for similar jaywalking incidents. If safety dictated severity, penalties would be consistent across demographics. Emerson's defense omits any rationale for that divergence. She tapped her pen. To ignore that unexplained gap risks eroding public confidence in the judiciary. A tense silence followed. Chief Judge Gates closed her eyes momentarily, then exhaled. We must also weigh procedural considerations. This council's mandate under the Judicial Conduct and Disability Act allows for private admonishment or public censure. We should deliberate on possible remedies. She nodded to Ortega. Proceed with potential resolutions. Ortega spoke first. Option 1. Dismiss the complaint for lack of conclusive evidence of intentional bias. Option 2. Issue a private reprimand, accompanied by mandatory bias training. Option 3. Public censure and referral for further oversight. He outlined each, placing a small placard beside his binder. Price leaned forward. I reject dismissal. This goes beyond ambiguity. Private reprimand may remedy personal conduct, but public censure sends a stronger message, reinforcing that judges must be held accountable. Yet we should allow Emerson to appeal within 30 days before finalizing any sanction. She glanced at Gates. This preserves due process and demonstrates transparency. Chief Judge Gates tapped her gavel softly. Noted. Let us consider the impact. Public censure could damage the court's reputation, yet inaction risks greater harm. A reprimand may be insufficient to restore faith among those who witnessed disparate treatment. She turned to Price. Do you propose censure with an option for Emerson to engage in corrective measures? Price nodded. Yes. Public censure, coupled with a requirement for Emerson to complete an approved implicit bias program and submit periodic progress reports for 1 year. She slid a draft resolution across the table. This is measured yet unequivocal. Ortega picked up the draft and read aloud. The council hereby finds that Judge Harold Emerson's imposition of disparate fines on defendants of different races constitutes conduct prejudicial to the effective administration of the business of the courts. The council censures Judge Emerson, orders completion of bias training, and requires quarterly reports to the Judicial Council for 12 months. He looked to Gates. Is that our consensus? Gates removed her glasses, steepled her fingers, and gazed at both colleagues. I agree, with one amendment. We should include a statement acknowledging Emerson's long service to ensure this censure is framed as corrective, rather than purely punitive. She tapped her notes. Add a preamble recognizing 29 years of meritorious service, then delineate the findings and required actions. She reached for her pen. Price began editing the draft. Preamble. Whereas Judge Harold Emerson has served the district court with distinction for nearly 3 decades, yet the council finds his recent rulings produced undue disparities, inconsistent with constitutional guarantees. Ortega nodded. That balances respect for institutional history with the need for accountability. Gates signaled for a vote. All in favor of the amended resolution, say aye. Aye, Ortega and Price chorused. Motion carried, Gates declared. Clerk, prepare the final opinion for signature. The public announcement will follow tomorrow morning. Counsel Jackson and Judge Emerson will be duly notified. She drummed her fingers on the gavel. Meeting adjourned. The next morning, Washington correspondents buzzed as the Fifth Circuit released its formal opinion. Robert read the emailed PDF at his desk, heart pounding. The opinion acknowledged Emerson's long tenure, then concluded, the council finds that, although Judge Emerson's intent may not have been malicious, the unexplained disparity in fines for racially comparable cases created an appearance of impropriety. Accordingly, the council orders a public censure, mandatory bias training, and quarterly reports for 12 months. It further noted the option for Emerson to seek review by the Judicial Conference within 30 days. A smile cracked across Robert's face, relief mingled with cautious optimism. He messaged Laura Chen. Council issued censure. Mandatory training and oversight ordered. Opinion issued at 8 a.m. Her reply came swiftly. Excellent work. Press office preparing release. We must emphasize corrective nature. Across town in his wood-paneled chambers, Judge Emerson stared at the official notice on his desk. His hands trembled slightly as he skimmed the language of censure. He stood, pacing between windows overlooking the courthouse plaza. Flashes from news cameras below captured the moment for local broadcasts. He drew in a slow breath, then sank into his leather armchair. "I see," he muttered, glancing at volumes of case law on his shelves. He reached for the telephone. "Walter, summon my clerk and schedule bias training sessions. And notify my liaison. I will review the option to appeal." His reflection in the window showed a man at a crossroads. Dignity intact, yet humbled. Even in rebuke, he acknowledged that the council's decision affirmed the importance of impartial justice. His voice was steadier when he returned to the phone. "Inform the judicial conference that I intend to comply." "Thank you." That afternoon, Robert convened with James Harris to share the outcome. Harris's face lit with cautious triumph as Robert explained the censure and oversight orders. "This matters," Robert told him. "It sets precedent that bias, whether conscious or unconscious, cannot stand unchallenged." Harris nodded. "I never imagined a jaywalking ticket could change so much. Thank you for listening." They shook hands firmly, an unspoken bond formed in the pursuit of fairness. Later in the office, Robert gathered Aisha and Laura. They reviewed the press release, quotes reinforcing respect for Emerson's career while underscoring the council's role in upholding equal protection. Journalists lauded the decision as a landmark for judicial accountability. Social media again buzzed under the hashtag #EqualJudgment. As dusk edged toward night, Robert walked through his quiet hallway, reflecting on the long journey from a morning fine to a formal censure. He knew this victory was but one step in a broader struggle for justice. Yet today's outcome affirmed his belief. When data, integrity, and courage converge, even the highest benches must answer to the promise of equality under the law. The catalyst for change. Sunlight filtered through the windows of the Brookfield State Capitol's hearing room as Robert Jackson stepped to the witness table. He adjusted his tie and placed his prepared remarks on the polished oak surface. A panel of state legislators, senators and representatives from urban and rural districts, watched with measured attention. The fallout from the Fifth Circuit's censure of Judge Harold Emerson had sparked public outcry. Calls not only for individual accountability, but systemic reform. Today's hearing would determine whether Brookfield would codify standardized guidelines for minor infraction penalties and require periodic judicial audits. Robert cleared his throat. "Good morning, Chairwoman Rivera and members of the Judiciary Committee. I appear today to urge enactment of Senate Bill 2147, establishing a uniform fine schedule for nonviolent misdemeanors and mandating annual bias reviews of judicial decisions." He began by summarizing the Emerson case, the seven-fold disparity in average jaywalking fines, the council's public censure, and the mandatory bias training imposed. While discipline in that instance was appropriate, legislation is the surest safeguard against uneven enforcement in every courthouse across our state. He outlined the bill's three core provisions. Uniform. Fine schedule. A tiered matrix categorizing infractions, jaywalking, open container, loitering, each paired with a defined fine range, 25 to 75 for first offense, 50 to 150 for second. Judicial analytics audits. A neutral commission within the Administrative Office of the Courts to publish quarterly statistical reports on sentencing patterns by race, gender, and zip code. Mandatory training and transparency. Judges must complete certified implicit bias education every 2 years and post a summary of sentencing rationales for nonviolent misdemeanor cases online. Robert referenced data from 15 neighboring states where similar measures had reduced fine disparities by over 60% within a year of enactment. He emphasized the human impact. For Mr. Harris, a college student working 2 jobs, a $600 fine meant forfeited wages, missed classes, and emotional distress. Standardized penalties prevent such undue hardship and reinforce public confidence in fairness. When he finished, the room remained silent for a heartbeat before Chairwoman Rivera spoke. "Thank you, Mr. Jackson. Your testimony is compelling. We also have Mr. James Harris, whose experience catalyzed these reforms. Please join us." Harris rose, walking with quiet dignity to the stand. "Members of the committee, I'm a sophomore at Brookfield State University studying criminal justice. When I received that fine, I felt powerless. Like the system saw only my skin color. But Mr. Jackson's stand showed me that one person's voice can spark change. I support this bill because it will ensure no one else in Brookfield feels the isolation I did. He paused, sweeping the chamber with earnest eyes. Justice isn't real if it depends on who you are. This bill makes justice real for everyone. A murmur of approval rose as Harris returned to his seat. Next, civil rights advocate Aisha Patel presented expert analysis on implicit bias. She walked through statistical models demonstrating how even experienced decision-makers unwittingly impose penalties that correlate with a defendant's race more strongly than with offense severity. She argued that transparency and data-driven oversight would not hinder judges, but empower them. By illuminating patterns, we give judges the tools to correct course before bias takes root. Finally, Judge Emerson's counsel, Martin Hayden, approached the lectern. Members, while we share the goal of equal justice, this bill risks eroding judicial discretion and undermining separation of powers. Flooding courts with data demands and public reporting may discourage judges from exercising reasonable judgment. Instead of statutory mandates, we recommend enhancing existing peer review mechanisms within the judiciary. He cited Emerson's willingness to undergo bias training and contended that local oversight, not legislative intervention, offered the best path. Several legislators leaned forward, pens poised. One asked Harris whether he believed standardized schedules could ever account for unique case factors. Harris replied, "Guidelines preserve discretion for aggravated circumstances, repeat offenses, or public safety risks. For first-time, nonviolent infractions, a clear slate prevents arbitrary disparities." Another questioned the bill's cost. Robert had anticipated this and explained that initial implementation would require a modest allocation, less than 0.02% of the state judiciary's annual budget, for data analysis staff and training. Long-term savings emerged from reduced litigation over fine appeals. After 2 hours of testimony, Chairwoman Rivera closed the hearing. "Thank you all. This committee will review the record and draft amendments. We may convene a second session with the Administrative Office of the Courts." The gavel fell, and Robert gathered his materials. As he exited, legislators approached him with questions about next steps. Staffers collected expert briefs and contact information. Outside the hearing room, Robert and Aisha reflected on the day's proceedings. "They took it seriously," Aisha observed, scrolling on her phone to read preliminary legislative reactions. "Several members mentioned your data, Robert." "That's a good sign." Robert nodded, though concern lingered. Politics often diluted strong proposals. "Now the real work begins," he said. "We'll need to track any amendments and mobilize community support." Meanwhile, in Brookfield's historic courthouse, Judge Emerson penned op-eds for the local paper. Under a headline, "Protecting Discretion, Ensuring Fairness," he acknowledged the merits of data-driven oversight, conceded that greater transparency could bolster judicial credibility, and offered to serve on an advisory committee to implement the bill. He urged the legislature to work in concert with the judiciary, not against it, stressing collaboration over confrontation. His tone, humble yet firm, earned cautious praise from some quarters, and skepticism from others who felt he still deflected responsibility for past disparities. That evening, Robert convened a virtual strategy call with civil rights organizations, student groups, and local bar associations. He walked them through likely amendment proposals, some seeking to expand mandatory reporting to all criminal cases, others aiming to introduce sliding scales based on income. He urged caution. Incremental progress would secure foundational reforms. Overreach risked stalling the entire effort. Group chats buzzed with enthusiasm as Robert outlined volunteer sign-up links, testimony slots, and social media toolkit suggestions. 2 days later, a bipartisan group of 5 legislators introduced the bill with amendments to include a pilot program, allowing community service alternatives for low-income defendants. That afternoon, media outlets covered the development. Brookfield bill aims to tame traffic ticket disparities. And, from jaywalking to justice reform, how one case changed the conversation. Robert forwarded the articles to Laura Chen, who replied, "This is momentum. Keep me posted." Robert typed back. Tomorrow we meet with Rivera's office to fine-tune language. Late into the night, Robert reviewed a draft that preserved uniform fines, but allowed judges to reduce penalties through written justification, subject to quarterly audit. He highlighted this compromise in an email to Aisha. Protects discretion, ensures transparency. She approved, noting it hits the sweet spot. As he hit send, Robert paused, reflecting on the journey. A jaywalking ticket, a federal complaint, a public censure, and now, legislative reform. He thought of James Harris, whose courage had ignited change, and of Judge Emerson, whose own humility had helped bridge institutional divides. Robert leaned back and closed his eyes. The struggle for justice was never static. It evolved with every challenge, every compromise, and every act of accountability. Tomorrow, the legislature would take another step towards cementing fairness in law enforcement. And no matter the final outcome, the Emerson case would live on as a catalyst for change. Proof that in a democracy, even a single penalty could spark a movement. A new dawn of justice. Sunlight filtered through the tall windows of Robert Jackson's office on the morning Brookfield's uniform fine schedule went into effect. He stood beside a sleek lectern in the U.S. Attorney's lobby, flanked by community leaders, civil rights advocates, and, to his quiet surprise, Judge Harold Emerson. The polished marble walls echoed with the soft hum of anticipation. Before the cameras rolled and the press gathered, Robert exchanged a brief nod with Emerson, a gesture that spoke volumes of mutual respect, forged through trial and reconciliation. Nearby, James Harris adjusted his cap, now embroidered with the seal of Brookfield State University, having just been awarded a scholarship fund seeded by the legal community to offset the disproportionate penalties he once endured. Together, they represented the journey from injustice to systemic change. Robert stepped forward, clearing his throat. Today marks the culmination of efforts by many, a coalition of voices demanding fairness, transparency, and equity. The uniform fine schedule, implicit bias training, and judicial audits will ensure no citizen suffers a penalty that depends on skin color. He turned to Emerson. Thank you, Your Honor, for embracing accountability and for your leadership in implementing these reforms. Emerson offered a measured bow of the head. His voice was steady. Mr. Jackson, Mr. Harris, and all who champion this cause, thank you. I pledge to honor this renewed covenant between the judiciary and the community. The assembled crowd applauded, and flashing lights recorded the moment for posterity. Later that afternoon, in a stately room of the Brookfield County Courthouse, a gathering of judges, clerks, and court staff convened for the first mandated bias awareness workshop. Emerson, no longer on the defensive, stood alongside his peers as Professor Samuel Wilcox led an interactive session on unconscious associations and decision-making. Cases were reenacted, transcripts analyzed, and participants practiced reflective techniques designed to surface hidden assumptions before they could influence rulings. Emerson shared his own experience, acknowledging the humbling lessons learned since the council's censure. We must view justice not as static doctrine, but as a living mandate that evolves with our collective conscience. His openness inspired thoughtful dialogue and genuine commitment among the judiciary. Meanwhile, James Harris returned to campus with renewed vigor. The scholarship fund, branded the Jackson Harris Justice Endowment, covered his final 2 years of tuition and provided stipends for community service projects. He joined the student government's Public Safety Committee, helping draft proposals to improve crosswalks and pedestrian signage in underserved neighborhoods. His first initiative successfully lobbied the city council to install flashing lights at 2 high-risk intersections, reducing jaywalking incidents by 30% within 3 months. Harris often reflected on his transformative journey, from a humiliating $600 fine to becoming a fixture in local policy reform, and shared his story at orientation events to encourage civic engagement among freshmen. Back at the U.S. Attorney's Office, Robert convened a strategy meeting to monitor the statewide rollout of the new guidelines. Data analysts reported quarterly metrics. Average fines for first-time, nonviolent misdemeanors held steadily between $25 and $75, and racial disparities shrank to under 10% variance, a dramatic improvement from the prior 7-fold gap. At each office town hall, Robert and Aisha Patel emphasized that continued vigilance was essential. Periodic audits would catch anomalies, and community feedback lines remained open for citizen reports. Justice is not a final destination, Robert reminded his team. It's a process we must nurture daily. Emerson, too, found renewed purpose beyond Brookfield. He accepted an invitation to serve on the State Judicial Conference's Committee on Court Equity, collaborating with colleagues from across the Fifth Circuit. There, he contributed to drafting model guidelines for small claims and municipal courts throughout multiple states. His influence helped secure adoption of the uniform fine schedule in 2 neighboring jurisdictions within 6 months. He also authored a chapter in the ABA Journal recounting his personal reckoning with bias, an article titled, "Humility on the Bench, A Judge's Journey," which became required reading in several federal judicial training programs. As autumn arrived, Brookfield's courthouse plaza once again bustled with the steady flow of citizens. A bronze plaque near the main entrance now bore an inscription, "Let justice be the constant guardian of equality." Below it, a small reflection pool invited passers-by to pause and consider the weight of those words. Each morning, Robert walked past that plaque en route to his office, recalling how a single jaywalking ticket had triggered a series of events that reshaped local law. Wednesdays remained court days for Emerson, now more conscious than ever of each case's human dimension. Visitors often saw him consulting his annotated docket with renewed care, mindful of both precedent and empathy. In the evenings, Robert and Harris co-hosted a youth civic education series at the Brookfield Community Center. They spoke about the power of individual agency in affecting change, and demonstrated how data and storytelling could amplify marginalized voices. Harris recounted the fear he first felt under Emerson's harsh penalty, then described the hope ignited when Robert stepped forward. Their partnership, once adversarial, now collaborative, embodied the possibility of transformation when justice systems engage, rather than dismiss, those they serve. On the anniversary of the initial hearing, a small ceremony gathered judges, legislators, nonprofit leaders, and ordinary citizens at the steps of Brookfield's red brick courthouse. Laura Chen unveiled a commemorative banner depicting an open book and balanced scales, its motto, "Accountability plus action equals justice." Emerson, standing beside Robert and Harris, cut the ceremonial ribbon. Applause rang out again, echoing along the avenue. For many, this was not merely a symbolic gesture, but a testament that even entrenched institutions could change when challenged thoughtfully and persistently. As dusk fell, Robert lingered on the marble steps, watching the lantern-lit windows of the courthouse blaze against the night sky. In the distance, Harris rode by on a bicycle, his textbook strapped behind him, a bright smile greeting Robert's wave. Emerson's figure receded into the illuminated portico, ready for the next hearing. The uniform fine schedule had taken effect. Quarterly audits were underway. Legislative allies pressed for expansion into civil infractions. The fight for justice continued, not in grand proclamations, but in everyday actions. A student safely crossing the street, a judge reviewing a case with fresh eyes, a community once marginalized now engaged in dialogue. Robert closed his eyes and inhaled the cool autumn air. The journey from a single, unjust fine to systemic reform had been arduous, marked by confrontation, concession, and heartfelt determination. Yet tonight, as the courthouse bells tolled, he felt a profound sense of renewal. Justice, he knew, is never static. It thrives in the hands of those willing to question, to listen, and to act. With that thought, he descended the steps, ready for tomorrow's challenges, confident that a new dawn of justice had truly arrived in Brookfield.